Next up on This Week in Law, we've got Evan Brown, Fark's Drew Curtis, Hallie Suit, and me. Does the FCC want net neutrality dead? Will the Authors Guild undo the fair use doctrine? Did the Supreme Court grok Aereo? And how does FARC use its legal war chest? All this and more on This Week in Law.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is Twill, This Week in Law with Evan Brown and Denise Howell, episode 256, recorded April 25th, 2014. Kentucky Fried Patents. This episode of This Week in Law is brought to you by NatureBox, where you can order great tasting, healthy snacks delivered right to your door. Forget the vending machine and get in shape with healthy, delicious treats like chili lime pistachios. To get 50% off your first box, go to naturebox.com/twit. That's naturebox.com/twit. Hi, folks. I'm Denise Howell, and you're joining us for This Week in Law. I am so excited about today's show. We've got just an awesome panel for you and great topics in the news and in our panelists' areas of interest and expertise. First of all, of course, joining us as he does every week, my co-host, Evan Brown. Hello, Evan.
Hi, Denise. How you doing? Happy Friday.
Happy Friday to you. I'm doing wonderfully. Can't wait for this discussion today. So much has been going on.
I agree. There have been a couple interesting things going on this week. So yeah, should be a good one. I bet it'll be fun.
Yes. So Evan and I have been knocking around the internet. We're both, getting up there in years, as you might imagine, for a long time. So we remember back in the early 90s when Fark.com was founded and was the place, and continues to this day to be the place that you go for your news and information and best links of stuff that's happening in the world. We're very fortunate to have with us today the founder of Fark.com, Drew Curtis.
Hey, how's it going?
Going great. Great to have you on the show.
Thanks.
Also joining us, returning as a panelist to Twill, is Hallie Suit Tucker, our author in residence. Hello, Hallie.
Hey, how are you guys?
Doing great. Great to have you back.
Good to be here. I brought my newt neutrality.
Oh, good.
I mean, he's a newt, but I call him neutrality for short. So.
Well, I think that's where we should go with the show first, since there's been much in the news this week. Probably the most recent breaking policy news has been on that front. So why don't we try and unpack what's been going on there?
This is unpacking music.
Give you a lot of unpacking.
Yes. Get your newt and unpack it and bring it out. So what has been going on, in case you haven't been paying attention, is it appears that a draft of something that was to be forthcoming from FCC Chairman Tom Wheeler's office, the forthcoming Open Internet Notice of Proposed Rulemaking. I'm not sure if all or part of it was leaked. I actually never read the full Wall Street Journal coverage that broke all this because I don't have a subscription. But there has been much coverage in the wake of it. What I haven't gleaned is whether the whole thing leaked or not. But it is definitely on its way to us. It was. I'm a little confused as to why it didn't come out yesterday, because there were a whole lot of representations that it would. I haven't seen it yet, but that has not stopped there being a whole lot of speculation and commentary about what this new proposed rulemaking will mean. Everything, there have been a lot of very scary headlines, such as the internet has been sold out. The internet has been axe murdered or will be if this goes forward. That last headline, courtesy of a great piece by Dan Gilmore, really laying out in no uncertain terms the threat to consumers and every internet user out there if a truly how do I put this? Lane gated internet is what we wind up with as a result of these rules. In response, FCC Chairman Tom Wheeler yesterday posted something on the FCC blog saying, everybody calm down. We remain behind an open internet. We, remain committed to the fact that anything that is unreasonably non-competitive, that is not commercially reasonable, that we're not going to allow that. We remain committed to the fact that, and here's the exact language, that ISPs may not act in a commercially unreasonable manner to harm the internet, including favoring traffic from an affiliated entity. So they are paying attention to this concern that Comcast, as owner of NBC Universal, should not be giving preferential treatment to its own property, for example, and allowing that kind of video stream to have better internet delivery than anybody else. But what does appear to be on the table is the notion that companies like anybody who wants to have a faster channel through an ISP like Comcast will have the ability to pay for that kind of delivery channel. So we're, mostly what that will apply to is very video intensive sites like Netflix, for example, or NBC Universal would be able to pay to have their delivery to consumers in a faster and more reliable way than perhaps someone who has not paid for such service. So why this is so concerning to people is it seems to upend the notion of a completely neutral internet where everything is delivered as well as it could be based on traffic and abilities at that time, that certain people will be able to pay for preferential treatment, and that the ISPs are getting paid on both sides. They're getting paid from the consumers for a certain level of service, and they will begin to be paid by the people who want to have really premium service for delivery to consumers. So there's much hand-wringing about this. The FCC wants people to remain calm, but there does seem to be an ability here for a non-neutral and less consumer-friendly internet to be the outcome. So teeing it up, I'd love to go around and see what you all think of this. Evan, let's start with you.
Well, no doubt it's a big lightning rod issue. People, I think it's a habit of a lot of people to prejudge a lot of these issues. When if you know you're going into a discussion about net neutrality, people formulate, for the most part, how they feel about it, and anything to the contrary of, extreme openness or whatever in the network is met with a lot of disdain. And I'm greatly generalizing, but it's a polarizing issue. So first of all, I would say, let's chill out. We don't even have anything to look at really here. We just have essentially a pronouncement, as you've said, Denise. There's just this indication that something is coming, which really is only going to be an indication of something else coming later, namely the rules that actually implement this. And so there's, I think if we want one who wants to maintain his or her credibility about talking about these things ought not to be using hyperbole and ad hominem sort of attacks at this stage and right now. Let's keep our heads about it. So with that said, if to take on a substantive critique of one who would say that anything less than a completely open and completely neutral network is anathema, let's look at why this is even an issue at all. The real heart of it is the presence of this fast lane here, or the ability for internet service providers to enter into arrangements whereby there is a fast lane of traffic to the consumer's home. If there weren't at least something good or something redeeming about having that ability, it wouldn't be an issue at all. Clearly, if it's actually going to come into reality, if the FCC allows this to happen and that there are these sorts of arrangements entered into and these purchases made, it's because the consumers want it. it'd be pretty awesome to have, super high definition Disney content, for example, to come into your home. Maybe you have a home theater and you want to watch something in really, really high quality and really high fidelity sound. Think of technology, what it'll be like, 10 years from now, even like what's after 4K, for example. So why not, what is, I guess, and I don't want to sound like I'm necessarily advocating, because I'm just trying to be moderate and trying to see both sides in all this, but why not start from the premise that there could be something redeeming, something good about a system where if you want to be able to be ensured that you're going to get a good experience because you have paid for premium access to the delivery of content through an enhanced mechanism, why is that necessarily inherently bad? Is the question that I would want to sort of take into the things as we see them unravel or unfold, unravel, however you have it on this.
Well, I kind of like that idea, Evan, where it would be sort of on demand from the consumer's side to initiate. So that, unfortunately, that would mean that someone like Disney would have to pay for the fast lane anyway, but then it would only be delivered if that's what the consumer had asked to have happen and the consumer was willing to pay for as well. That's certainly one way that this could go. I'm kind of skeptical that it would go that way. Hallie, what is Newt worried about?
Well, me and Newt, we're not lawyers, but Newt, he's just like a kind of real innovator, and he wants to put a show on. He knows that social media has run a range from, it used to be all written blogs, maybe around 2000. Then we're seeing more and more social media that's pictures plus words. Then we're seeing a lot less words, a lot more pictures and video. And he knows his show is going to stink and nobody will watch it unless it's got video. And he's really good on video. He's a real mover and a shaker. So the point is here's what he says late at night to me. He's like, do those people actually want to make it fair for everybody? Is this neutrality idea fair to get everybody a chance to communicate with everybody? Or are they just in business and they want to keep their business the way it's been? And, he reads Consumer Reports when he's not bugging me. And he's read the first consumers, this was January, how to get better deal on your phone. And why is that? Because the phone people, you feel a bit as a consumer, you can't trust them. Then he read in March, there was consumers on best deals on TV. Oh, there's Netflix and Amazon and Hulu. And we're suddenly got all these different choices. And who do we trust there? And then by May, he read this one and he went into a panic, break free from cable. So he's like, all these people who run this and make these decisions are in businesses where they're losing their shirts. At my house, we got rid of cable. We just have local TV, and we have Hulu, we have Amazon, we have when we want to watch movies and TV. So everything's changing a lot. And as a consumer, but also as a producer of content and communication with other people, he wants a fair internet that lets his show get to as many people as fast speed as possible. But, he's difficult. If you want him to come live at your house, I'll send him. He's getting very annoying. But
I'm afraid I can't guarantee him a fast channel to his subscribers either, unfortunately. Newt's going to have to start saving up and perhaps have a fund set aside for that. And I share your concern, Hallie, that small businesses are going to find that a challenge. As someone who runs an 8-person shop, Drew, what do you think about all this?
Yeah, so interestingly, I have even more perspective than that. My first company was a dial-up internet service provider that I started in 1996. And what happened there with DSL is very similar to what's probably going to happen with net neutrality, in that it's all right for Comcast to say, no, we won't degrade the service. Anybody who's capable of paying, we'll just let them do it. But the problem we had with the DSL rollout was Bell South had an internet side also that it would charge the same rates to as everybody else. But if you think about, at some point, these companies converge at the top and money just flows from one side to the other. So you're not talking about a serious outlay of cash by your number one competitor. And then they ended up pricing the tiering so that as a small ISP, we had at most like 3,000 customers. In order to get any kind of margin off of it at all, we had to guarantee that we could sell 150,000 DSL lines in 2 years. Well, the only company capable of doing that was bellsouth.net. And by default, they, within 2 to 3 years, ran every internet service provider in their region out of business, simply by money from one side of the balance sheet to the other. And that's all it took. And me because AT&T's CEO and others have gone on record saying that they feel like they should own the internet, that they should own Google, they should own Amazon. And in my opinion, this is just a step in that direction. In the very least, it's just going to be a straight up lockout, unfortunately. So yeah, I think this is really dangerous to the open internet. I mean, if you like the companies we have right now running everything, if you don't mind Disney and Amazon and Google and all these guys just owning it, then, you know, there's nothing to worry about. But me personally, I don't know that this is going to work for me at all.
Yeah, I think you echoed some of the points that Dan Gilmore makes in his piece. He lays out pretty dramatically the downsides of this, and then tries to offer some good responses, how we can deal with the problem. He is a big fan of community broadband networks. Getting behind those would create more competition. He's a big fan of requiring the ISPs to share their lines at a fair price with competing ISPs, and points out that other countries do this and maybe we should give it a try. And then he ends with what he calls the best solution: taxpayers should pay for a fiber everywhere system and then let competing ISPs use it to compete in a genuine free market. But he says, don't hold your breath on that one.
Wait.
So
it's a government-owned network, but it's a free market? That's what he's proposing?
Well, he doesn't say who owns it. Taxpayers should pay for a fiber everywhere system, but he's not saying who the taxpayers are paying. You know, if
I'm gonna have
that's
to think about that one. Yeah.
Yes.
But anyway.
That idea has been floated for the last 15 years. It came up when the DSL thing was around, and it's not really easy to convince people that they should cough up billions of dollars for a network that, if you think about it, it's like old people don't know it's there. Those of us our age are aware of it as a separate entity, but my kids don't even know the internet exists. They know that they do stuff that's connected to it, but they don't think of it as a separate thing.
Yeah.
Yeah, that's an excellent point. All right, so there's rulemaking coming. We do know this. We know that it will be out for public comment. We know that once its text is available to be parsed, we'll know exactly what the ramifications are. There's a lot of concern about what commercially reasonable or unreasonable means, and hopefully there will be some parameters there. I do think that just based on the reaction to the fact that an internet fast lane is a possibility, that the FCC is going to be getting a lot of pushback and information about this. So we'll just have to see what happens. It's the funny thing about Dan Gilmore's piece here is how many times, it's at least 5 or 6 times, he refers to FCC Chairman Tom Wheeler as former cable and wireless industry lobbyist FCC Chairman Tom Wheeler. So we know what Dan thinks about Wheeler's affiliation and proclivities. But again, this is just kind of a wait and see thing. The other thing that we haven't discussed is the possibility, as the DC Circuit left open in its court decision invalidating the original open internet rules, of reclassifying broadband as a common carrier and going after regulating it that way. Tom Wheeler in his post points out, and of course I already shut that, but he points out that if you reclassify, there's still a commercially reasonable standard that that comes into play there. So we're not really accomplishing much by reclassifying. We're still bound by that same sort of amorphous standard. So we're going to need to get some clarity on that before I think people feel good about adopting the new open internet rule. Any final thoughts on this, Evan?
No, I mean, other than just to reiterate, as for me, I'm going to try to show restraint on saying too much about it, because this is just, it's just way too early in the game, and something meaningful has to happen one way or the other. So let's just, before we start throwing stones without understanding things, try to see what's actually being proposed here.
Hallie and Newt, anything you want to kick in?
I wanted to get a definition of commercially reasonable. What is that? You guys are the lawyers. I really find that confusing.
Well, I think it's safe to say that one thing Tom Wheeler would consider commercially unreasonable is if Comcast, as overarching owner of NBC Universal, were giving its own content network, NBC Universal, some sort of more preferential treatment than anybody else was able to get. That would, I think, pretty clearly be commercially unreasonable. But, once you get away from those clear examples, you're right, Hallie, It gets a little difficult to pin down. What exactly Tom Wheeler said as far as reclassifying to the other regulatory scheme is that even Title II regulation, he says, which many have sought and which remains a clear alternative, only bans unjust and unreasonable discrimination. So we're kind of in the same boat, whichever category we put this under. What were you going to say, Drew?
Well, I think the way that it's currently looking, it's going to be degrading service by default. We'll just upgrade everybody willing to pay for it, and we won't touch anything else. Well, it ends up being the same thing at the end of the day.
Yeah.
Yeah, and what I hate is, if you're a wealthy consumer and you can pay for a certain very high level of internet access, that even then your ability to get everything at a high level of delivery is not going to be guaranteed. And I worry about the non-wealthy consumers who are paying for a base level of internet access. And I think that that's where you're really going to see the degradation. But again, we are speculating and should wait to see what's actually in the proposed rulemaking, and we'll go from there. One thing, again, that we're waiting for is the decision in the Aereo case. That was argued on Tuesday and has a great impact on entertainment and television, as we know. So let's talk about that next. So the Supreme Court heard oral argument for an hour on Tuesday in the Aereo case. And the justices telegraphed some concerns. We can't really know how they're going to come out, but we know that it doesn't seem like any of them. I like to talk about litigants who wear white hats and black hats. Are you coming into court, with a fair and just and good story for the court to try and get their teeth into, and can they really get on your side? Are you wearing the white hat? And I did not come away with the feeling that any of the justices thought that Aereo was wearing the white hat here. They spent a lot of time during Aereo's portion of the argument trying to get to why exactly they designed their system with all the little tens of thousands of tiny antennas when one would be more efficient, and seemed sort of fixated on the notion that they're driving that antenna farm through a legal loophole. And, who knows how much that will shade the court's analysis, but I always think that white hat, black hat thing plays in. Evan, you very quickly after the argument posted a link to the full transcript. Did you get a chance to read through it all?
I didn't read through it all. I listened to some of it, but I've relied mostly on commentary from people who have hopefully actually read it. There's a good article on Ars Technica. I think it was Joe Mullen, right? Yeah, on the 22nd, who summarizes it, I think, pretty well. An hour-long hearing. It's a long time to listen to,
right.
or a lot to read through on this, but. I get a new sense, I mean, of course, hopefully after, learning about what the hearing was actually like, sort of a new sense and a new perspective. There seems like there's this desire on the court's part to want to, what's the word I'm looking for? To come out not on the side of Aereo, or to somehow protect the cloud without coming out on the side of Aereo, more precisely, because there's been this tendency in our commentary to say that if Aereo loses, the cloud loses, or if Aereo wins, over-the-air broadcast loses, or something. I hope I'm getting that matrix straight. What we've been talking about here. There seems to be some legitimate concern on the part of the justices. I know Justice Breyer, in particularly in his questioning, was very concerned about how to protect cloud services. Justice Sotomayor was like that as well. So they see this problem. They certainly recognize that as a real issue here, and it certainly is problematic. And I thought it was also very interesting. Another thing that sort of struck me by surprise is this was Justice Sotomayor at the very beginning saying, "Well, why is Aereo not a cable company?" And they gave me the idea, and I had lunch with an intellectual property professor here in Chicago, and she was saying that, well, maybe that's going to be the out for the Supreme Court on this. I've always said, well, the Supreme Court could do something strange here and not even really get to this question of the analysis under the transmit clause. And you got that indication from Justice Sotomayor's questioning and Justice Breyer's questioning at the beginning. Well, maybe they'll just find that it's like a cable company here and remand it on that basis, and then they don't really have I guess ostensibly for the time being it would ratify the technology, but doesn't get to the nuances of the way that one is supposed to read the transmit clause, which is really what we're excited to hear about, the analysis under Cablevision in the Second Circuit here. So it was interesting, and surprisingly, maybe Justice Thomas thought that Aereo was okay. He just didn't speak up on it. But yes, there was no sense that anybody in the room thought that Aereo was wearing a white hat in all of this.
Yeah, Hallie?
I don't know white hats or black hats, but in terms of innovation and entrepreneurial activity in this whole space, it's going to be incredible. So it's kind of exciting. I know it's a very big, I'm on my 30,000 foot ladder about what's happening, but these technologies are changing everything that's going on. I love the guy holding up the tiny little, this is your little antenna. And so it's just changing so much. I think it's going to be hard to see lawyers and regulatory chasing after entrepreneurs. It's one of my favorite things.
Yeah, and that Joe Mullen piece that Evan mentioned is a really good analysis of the argument. And Joe spent some time sort of armchair quarterbacking the lawyers and wondering, when they were being telegraphed some concerns by the court, why they didn't follow up and address those concerns, which is easy to do after the fact and harder to do when you're standing there in front of the justices of the Supreme Court. But he makes some good points on things that could have gone better at argument. Drew, are you following this closely?
Not super closely, but I'm sort of aware of the issue. I feel like this is whatever the decision ends up being is going to be on the level of importance with the whatever the case was back in the early 80s where the Supreme Court, I think it was the Supreme Court, decided to allow people to make personal copies of things on videotape. Is that right?
The Betamax case.
Mm-hmm. Yeah, I have a feeling like depending on which way this goes, I mean, this could be the equivalent of allowing or shutting down that capability. And so I think this is an unfortunate area where the decision they make in the basis of this case is going to decide it for an entire industry.
Ooh.
Yeah, no, I agree with you. And I'm trying to find, did I put it here? Yeah, here it is, the first link in our rundown. Derek Khanna, who we've had on the show before, did a really nice analysis of not so much the argument. I think it was actually written before the argument, but just of the issues in the case. And goes back and really goes into the history of Sony Betamax and the arguments that were being made there about how, according to the people who wanted Sony driven out of business, it was going to shut down the motion picture and television industry altogether. And Jack Valenti comparing the VCR to the Boston Strangler to a woman at home alone. And I mean, we're seeing similar kind of hyperbole here. And I think Derek does a really good job of showing how, we're kind of reliving that scenario and that the same kinds of concerns are at issue here. He also points out, and this is the first I've seen anybody mention of this, that if as the entertainment industry says, in the event of an Aereo victory, they are going to stop doing free broadcast television of the kind I assume you're getting at home, Hallie. If they actually do shut that down, what a boon that will be for innovation in mobile and telecom because of all the spectrum that will be freed up.
Yeah,
exactly.
That's great.
So,
be careful what they wish for.
Yeah, exactly.
It will. It's amazing. Even now, I feel like there's something I'm going to call like retro innovation going on, where we're going back. I dusted off the DVD player. I'm using it instead of, DVR. And we're just doing all these things and messing around with all the choices in ways that are fun. And as an entrepreneur, I'm just like, oh my God, there's going to be so much going on in this space. So it's going to be very exciting.
Drew, what do you think about the unanticipated availability of spectrum here?
Yeah, no, that would be amazing. I just don't believe the threat that we'll shut everything down. I mean, that seems like kind of, I don't know, it's a bit far to go. I mean, but that would be awesome. I mean, think about all of the stuff you could do with it. I think they should totally shut down broadcast TV. That's a fantastic idea that I never would have considered. I'm glad they suggested it. Let's do it.
Yeah, hopefully that'll be a policy consideration the court takes into account.
Yeah. I mean, why couldn't they have said the same thing in 1984 after the VCR? I mean, if all this content is going to be infringed because you're taping reruns of, what is it that we've talked about? Like if it was popular in 1983, 84, Webster, on Friday nights, you tape reruns of that. That's going to kill.
Greatest American Hero. Let's go with that one.
There you go. Knight Rider, the good old days, the golden age. You can see what happened. Yeah, they had the Sony Betamax decision, and broadcast television went downhill from there because then, but the 90s. Anyway,
we never made any more money ever.
Right. So I mean, but look at how the VCR helped the home entertainment industry. It gave a whole new revenue source there. It's cliche to point that out. Despite what Jack Valenti said, there were billions and billions of more dollars headed to Hollywood because of the VCR. So I'm, waiting for a smart person to tell me to suggest what it is that suppose Aereo wins, the technology is validated by the Supreme Court. Broadcast television may or may not go away, but what is it that's going to give the boon to the content industry that nobody is foreseeing now, just like Jack Valenti did not foresee in the days leading up to the arguments before the Supreme Court over the technology of the VCR. I mean, there could be something just really, really interesting ready to happen here that's going to change the way we consume content. And I have no idea what that is. Maybe it's nothing. Maybe there's no space. Maybe there's just maybe there's no room for that sort of innovation that's going to be a boon to Hollywood. And I'm not looking, trying to be a Hollywood lobby here saying, we've got to find something to support Hollywood, but there very well could be something here, and it's something that, heaven forbid, we actually might enjoy something that comes from big content. So whatever that is, somebody let me know what that might be.
Derek makes a couple of other really good points I want to just point out before we leave this discussion. One is that the whole reason we're in this situation, the whole reason Aereo even exists, is because you should be able to do what Aereo gives consumers the ability to do through your cable or satellite television system anyway. You should have all that functionality. You should be able to watch TV on demand or live on your mobile devices in a seamless, nice way. And so the reason there's room for Aereo to come in and serve that niche is that the satellite and cable providers have dropped the ball on that innovation. They're trying, but they really haven't perfected that. I think anybody would agree. And so they've left this door open. And now that Aereo has driven through it, they're trotting out Boston Strangler type arguments again. But then the other point that Derek makes is within 2 years of the endorsement of home recordings in the Betamax case, far from Valenti's fears of doom and gloom, the content industry actually made more money from home video sales than from in-theater sales. And there's no reason to think that wouldn't happen here, as long as the satellite and cable companies have allowed another company to kind of scoop them technologically here. They're still going to benefit from the broader distribution of all the content. So, I think those are just great points as well, and that hopefully the Supreme Court has all of that in mind as it chews on the case and comes up with a ruling before the end of this term. Any more thoughts on this, Evan?
No, I don't think so. It's intriguing. So something might percolate as we're talking about something else, because I do think the way that it applies and the consequences of it clearly could be a harbinger to how other areas of technology law should be thought about. So, yeah,
yes.
It's all good.
Allie, how are you getting your broadcast TV? You don't have cable, so
yeah,
do you
we
have
got rid of it? Yeah,
do you have an antenna on your roof?
I bought this $9 thing. It's a receiver thing that's right next to my TV that brings in all the local channels. I got tons of local channels. What really happened was my 18-year-old went off to college. So he was the one watching cable. We realized, who cares? We don't need it. Other friends, every night we have a dinner party and we talk to people. They're like, get rid of it. You don't need it. And so we have that. And then we have a ton of, we watch a lot of series in the evenings and stuff. I was just going to add one thing. One of my most interesting things this week I've been reading that I think informs so many decisions about what's going on is the Pew Research. I think you probably all read it. The presentation about what's going on. This is like many of these battles are battles between old boomers getting ready to die and lots of younger, very more colorful and diverse, right, populations inventing what they need. I mean, our ideas of TV and cable, they're old. They're really old. And I'm very excited, maybe because I have an 18-year-old, to see the things they come up with. I mean, when they're using Snapchat and they're using all these other things, they're doing things that we don't have a clue how to serve the needs of that new set of people in this country. And I think many discussions are going to be informed by that. If anybody didn't get a chance to read the Pew Trust thing, and one of the great Twitter lines was, we're getting grayer and browner, right? Older. This is going to be an older population and a more diverse population. And they're very creative, and they hold nothing sacred when it comes to TV or, entertainment. Their idea of entertainment is so liquid. It's just interesting. So they have, Snapchat lasts for 10 seconds and they have a heck of a great time with that. And that's all they need, so.
Right. And they're going to need Spectrum. So
yeah.
We'll just have to see where that goes. Drew, any final thoughts on this?
No, I'm pretty good. I think that's all I've got. I'm sobering up is the problem.
Yeah. Don't do that. It's Friday.
I know.
All right. Well, as Drew alleviates his sobriety problem, it might be a good time to think about having a snack. If you are thinking about having a snack, you really want to hear about our sponsor for this episode of This Week in Law. And I think I will dedicate this sponsorship segment to everyone who works late at night. I've certainly been there, done that, starting in college when, I used to go study in the wee hours. to be able to really focus and get stuff done. And not at all because I'd been doing too many other things during the term to really stay up on my studies so that I had to cram for exams. And then once you get out into the workforce, of course, it's pretty easy to find yourself whether you're a coder or a lawyer or anyone else, needing those wee hours of the morning to really focus in and get your stuff done. Now, what I always found distressing as I was working away in the wee hours of the morning is that I would wander down to the office refrigerator and find that 8-day-old coworker's sandwich that they'd abandoned. And that was pretty much, my option for being able to get some nutrition and keep going. But thank goodness now you have some other way. If you follow that option, you're going to wind up as the poster child for the Dumb Ways to Die app, right? You just can't be doing that. And then don't go find those vending machines because mostly they're just full of junk. So what you want to do instead is you want to track down and subscribe yourself to NatureBox, because then when you're starving in the wee hours, all cranky and lightheaded, you've got something really cool and natural and satisfying. It's good for you and it's going to keep you going to be able to eat. You can keep your eye on looking and feeling great by going to naturebox.com/twit. When you do that, you click on the continue button to choose between 3 different subscription options. Then you place your order. Once you're a member, you can select which snacks you'd like in your monthly box, and you can have them shipped right to where you might be hanging out in those wee hours in the morning and need to reach for something good to snack on. If you're a vegan, you can select that. If you like to eat things that don't have soy, they've got you covered there. If you need to be gluten conscious, they have that as an option. Lactose free, yep, that too. Nut free and non-GMO as well. And you can pick what taste you like, savory, sweet, or spicy, and you can mix that up. Then it sends you these great tasting snacks right to your door or your office with free shipping anywhere in the US. And then you've got healthy and satisfying snacks on hand. Things like barbecue kettle kernels, French toast granola, chili lime pistachios. Oh my gosh, I got so hooked on those things. They are definitely a failing for me, but I don't have to feel guilty about it because they're good for you. And then here now, in our house, we got one Nature Box from the sponsor, and this is all I have left. And I've been hiding it. They're the sourdough cheddar pretzels. They are delicious. The bag is almost empty, but there is enough to get me through the show here. And so I love my son and my husband, but they are not getting their mitts on the last of these. All this stuff has 0 trans fat, 0 high fructose corn syrup, and nothing artificial. It's the snack happy gift that keeps on giving. You can get a 3, 6, or 12-month subscription for either yourself or someone special, family member or friend. And don't forget that swimsuit weather's almost here, so it's time to snack smarter. Leave that vending machine alone. Get in shape with healthy, delicious treats like honey mesquite almonds. So remember, to get 50% off your first box, go to naturebox.com/twit. Stay full, stay strong. Go to naturebox.com/twit. Evan, how are the NatureBox treats faring in your household?
Well, I'm really concerned about swimsuit season. I want to look my best. So I have been enjoying poppy seed sticks today. The bag is about down to here. Also cranberry almond bites, which I am working on as well, but really enjoying them. So I certainly second everything that you said, and we're about ready to actually make the decision to subscribe for ourselves and for some people that we know and love. So yeah, good stuff. Good stuff.
Great. And we thank them so much for their support of This Week in Law. All right. So one of the reasons we asked Drew on the show is Drew is a famous patent troll warrior and has successfully gone round the block with a patent troll. So we want to hear all about that. And since we're talking about patents, let's tip off the discussion with our fun little bumper. All right. So over at FARC.com, you guys have various legal concerns that have come up. You say the one patent troll that you've come across is the one that you soundly defeated. You gave a great TED Talk on this, Drew. So can you sum that up for us?
Yeah, basically, I threw the playbook out on how to deal with patent trolls. What you're supposed to do is just pay them. And they were coming in at a level where, I mean, the problem with the trolls in the first place is they sue you for an amount of money that's less than what it will cost you to fight. And they're counting on the fact that you can do basic math and that you'll just write them a check and leave. And any other outcome to them is actually less positive. So my problem is I'm from Kentucky, and I just don't like writing people checks for legalized extortion. It seems wrong. And I like to fight. So I basically went after the guy instead. And everybody told me I was crazy. And honestly, I felt like I was crazy. So I'm not going to say they were wrong. But I did everything in the normal patent troll playbook completely backwards. And lo and behold, it worked.
So they claimed to have a patent on distributing press releases?
Yeah, they claimed that it was a patent on entering information into a web form, and then an algorithm on their end would compile it into a news release, and it would email it to people. And they said we violated that patent.
And was there any kind of tie-in between that patent and what you do at FARC? Or do you think they were just firing a broad range and seeing what they could shake out?
So there's an interesting answer to that question. First of all, there was nothing remotely similar to what we do on the site. But that's when I realized that was the problem with patent law, because like anybody on this call right now could have been sued under the exact same circumstances, because the way patent law works, you have to prove you don't infringe. And so I was flabbergasted because, I mean, they literally could have just gone after anybody and gotten the same result, because they were asking for less money. And this is actually what the patent on scanning documents into email, owned by a company called MPHJ. They filed off at last count the number 16,245 threatening legal notices to all kinds of businesses that scanned documents into email and asked for a $1,000 per employee license. And nobody was immune to this kind of activity. They could just fire it off, and they collected tons of checks doing that. And in my case, they came after me expecting to do the same thing, but I ended up shooting him down. But the reason why they came after me is because they could not lose. There was no way. Basically, if I proved that we didn't infringe, they just dropped the case. And no problem there. They just get out of it. So since giving the TED Talk, I've come into contact with a number of people who do a much better job at fighting patent trolls than I do, because I'm not an attorney. And one of them in particular is Lee Cheng over at Newegg, who developed this strategy for Newegg back in around 2006 when he took over their legal affairs, and is running out of lawsuits to deal with. Every other retail company out there, Amazon, Walmart, these guys get sued all day long because they don't own patents. Newegg does not, because they fight every single one of them. And then when they win, they file a counter lawsuit to go after fees and the damages due to fees, and in many cases go after the attorneys who actually filed the things in the first place. And it turns out patent trolls just don't want to put up with that crap. And it's an amazing strategy, and it works really, really well. And I'm surprised most people don't do it.
Yeah, it's great to have you on the show. We've had Lee on the show, and he is, I think, one of our most popular guests ever.
He's awesome.
Because, yeah, folks are big fans of not rolling over and actually standing up to these trolls. So in your TED Talk, you asked for some screenshots of anything on your site that linked what you were doing to any kind of infringement, and that's what triggered them, you think?
Yeah.
Just
well, so
speculating
this is
to
a legal
finally
show,
settle.
I can go into the inside baseball version of this. Basically, we got to discovery, and we filed first. And we asked for two things that I think got me out of it. One was screenshots of actual infringement. And the other one was I dug up the names of 5 people that I thought were probably involved in this patent troll. And then I worked with my good friend Matt Cutts, who's also a fellow Kentuckian who is head of Google search engine, and he dug up 5 more names for me. So one of our items was, who are these 10 people? What is their ownership stake? Do they benefit financially from this lawsuit? And then they missed their deadline to respond to discovery, which, traditionally you're not required to, but it's customary to give them 2 more weeks to respond. But as you probably well know, if you miss your discovery response deadline, you can't strike questions. And that's when these guys rolled over.
Ah, brilliant. It's great that that worked out for you.
Yes.
What other sort of, I don't know, what other sort of interesting things happened during the course of pursuing this with them?
Well, what was interesting is that I was kind of surprised at how it went, because I was sued along with 8 other defendants, and it was like Yahoo, AOL, Dig was in there, Reddit was in there, Condé Nast, but all of these very large companies, and you have your first meeting where like, yeah, we're going to do joint defense, we're going to take them to the mat, and then every couple of weeks somebody drops out like clockwork, and I can't tell you how many times I've heard that same pattern over and over and over again. And it was brought to my attention by somebody who was a CXO level person in a large company, and I forget which. But they asked a really interesting question. They said, as somebody who's not an attorney, how do I justify to my board that I spent more money fighting these guys than I would have spent if I'd just written them a check? And my response has been, we've discovered a pattern in companies that are likely to settle are likely to get sued by patent trolls, because just like anybody else, they can run a LexisNexis search and find out how many times things have been just dropped. And so if I was a patent troll and I had a crappy patent, I would first locate people who are likely to write checks and probably just sue them and just collect checks and cash them. So it actually makes you a more likely target. If you think about it, it's the school bully in the lunch yard. He's going to go after the people that aren't going to fight. It's not that they can't fight, it's that they don't want to, because they'd rather just cash checks. And honestly, who wouldn't? I would.
Yeah.
So one of the things I was interested in, Drew, and we're so glad that this worked out for you and that you're not under NDA and can talk about it. That's one of the other things you pointed out in your TED Talk, is that oftentimes not only are people feeding the trolls, but then agreeing as part of their settlement process to keep quiet about it. And you just X'd that out of the settlement agreement when it came your way, and your lawyers said, oh, that'll never fly. And it did.
Yeah, it was kind of stunning, really, because when they called me up, the call was actually sort of scary. They said, you know what? They're like, look, we have never, ever seen anything like this before. And I was like, oh, great, here it comes. And they're like, yeah, we struck the NDA and they signed it. And I'm like, well, okay, let's sign it and fax it back, because let's get out of this thing. My goal there is that, I'd already spent a lot of money fighting this thing and it sucked. But one thing I could get out of it would be the ability to talk about it to other people and explain to them what we went through. And the other thing that happened is that there was still one other defendant in the case when we got out for $0, and that was AOL. So I called them up and I was like, guys, we just got out for $0. I recommend you start negotiating a settlement right around that number. My problem was I was tossed up between is it going to be 0, or should I ask them to pay my legal fees? And I went for 0 and they didn't counter, which means I lost some money there. But I'll know next time.
Yeah, definitely. Evan, do you know if Drew would have, if that's a good bargaining tactic for people who find themselves in Drew's situation? Is there a good basis to go after your fees in these cases?
Well, sure. I mean, a lot of it's going to depend. I mean, it's a little bit harder to get the recovery of your cost and attorney's fees in patent cases than it is in copyright cases. But, it's going to be a very case-specific inquiry to be made, what kind of leverage you can have, the strength that the other side has or feels that it has, whether they're going to be, paying you instead of settling for $0. And I guess the observation I would make on the non-disclosure provision, or the lack of a confidentiality provision in all this, it kind of goes both ways. Sure, in this case, it was a good thing because it was $0. But as you're talking about, Drew, there's sort of this blood in the water effect that can happen if you do settle these things, where the troll will see that, one party is willing to settle, and so the other trolls will come. I guess I'm mixing metaphors, sharks and trolls. But you get the point. Little green people with sharp teeth, and swimming around in the water. Yeah, there you go. Newts seem so placid, though, don't they? They're much more into these socialist issues like net neutrality. Anyway, now
to your point, Lee Chang actually would argue that you should always try to recover fees, and it's not a matter of whether or not you could get them at all in the first place, but it's because it's a deterrent. Trolls really don't want to fight, and you think about why. Trolls hire attorneys mostly that work on contingency, so they have to pay out of pocket for everything other than cashing a check. And so you're actually costing them money and you're burning them up in the process. And attorneys are risk-averse individuals, no offense, but all you have to do is convince them that they might personally be on the hook, and they'll just get the hell out of it. There's plenty of other easy targets. And so that's why Lee doesn't get sued anymore. It works.
Yeah, that's awesome. Wait, we had that as a tip on the show recently. You don't mess with Lee Chang.
No.
I'm curious to unpack, Drew, as the result of both your status as the founder of a successful website and also having gone through this go-round with a patent troll. If you are anti-patent or anti-troll, and I was wondering if you actually, or on behalf of FARC, have any patents.
I don't. It turns out, knowing what I know now, apparently I could have filed a ton of them, but, like legitimate ones too. But that said, like the only reason I would have done that now in retrospect, if I could go back in time to 1999, would be to prevent stuff like this crap from happening to me, basically. It's like, but in general, no, I'm not anti-patent. I think the problem is that it's anti-vague patent where you've got the issue of, for example, I've been working closely with Adam Carolla on the podcasting troll patent. And in particular, it looks like the reason this thing got approved in the first place was that there was a slight, what the patent clerk thought was an innovation in the thing was not what they got sued on. The patent troll is claiming to own a patent on podcasting. And it turns out that what he said the actual innovation was, and this is debatable because I still say this is a bunch of crap, but that there's a downloadable list component to it that makes it innovative. And I'm like, nah, it's still ridiculous. You got to be kidding me. So I think like I'm not anti-software patent necessarily either, but I have yet to see anything that I would consider to be a complete innovation. And the reason why I'm not is because it seems to me there are certain things that we should protect. For example, if I cure cancer, I don't want, Merck to go and deconstruct what I did and just run with it. It doesn't seem like that's a really good idea. But other than that, I would say I am not anti-patent, but I don't think there's a lot in the world anymore that you could probably say would qualify for one.
Okay. Hallie, any thoughts on patents and patent trolling before we move on?
I do. I really loved the TED Talk. It was great. Thanks. And can you mention you had that great data on how much it costs people and how much terrorism costs people, the comparison?
Oh, yeah. That was a great graphic in your TED Talk.
Yeah, that was a Boston University study that was online. It's cited in the media quite often. What I did was I added up the cost of essentially they racked up how much patent trolls cost, and then I sort of added it all together over the last 20 years. And then I looked up what the Iraq war cost. And it turns out that patent trolls have been more expensive than the Iraq war. And that's including the damage from 9/11, which you shouldn't necessarily lump together. But I did because it's still smaller.
Yeah, it was great. That was great. I really liked it. Everybody should watch that. It was a really good TED Talk. It was great.
Yeah, and I've got to say, too, that there's sort of scary things in the works. Like Intellectual Ventures is attempting to raise $5 billion in capital to, essentially sue more people. Well, here's the kicker is that company is structured like a venture capital outfit, which means at minimum, the implied pitch to investors who invest $5 billion in this company is that you will make 40 in the next 5 to 10 years. And that's just IV alone is expecting to extract $40 billion out of the economy. So I've been talking to friends of mine in the stock market, and I'm like, if you guys invest in these things, like you should get out. It's technically a pyramid scheme. And they're like, well, why is that? And I'm like, well, how much money are these guys going to extract from the U.S. economy before the government's going to step in and shut all this down?
Right.
I mean, is it $1 trillion? Because we'll get there. Is it 2? Because we'll get there. Is it 5? Because we'll get there. And you got to pick your number. But at any rate, this thing is accelerating. It's going up and to the right. And eventually, we're going to hit whatever that is where the government just throws the brakes on it and says, okay, we're going to stop this whole thing. And not only should hedge fund investors be worried about that, but people who actually own legitimate patents like Intel and Cisco should be worried about it, or people that paid a lot of money for patents like Google and Microsoft, because they're going to be eventually rendered worthless by this activity. And, they can let it continue, but it's pretty clear that at some point it's going to cross a threshold and it's going to stop.
Well,
it's interesting
I have 2 words for that. Commercially unreasonable.
Yes, there you go. That's a good definition.
Let's get the FCC involved.
Right.
All right. Well, one thing that we should do before we go too much further is drop an MCLE passphrase into this episode of This Week in Law so that if you're listening for continuing legal education or other professional credit, you can demonstrate that you've actually seen or heard the show and gotten the benefit of all the great insights and legal analysis that we're throwing at you today. So our first MCLE passphrase is going to be, drum roll please, Evan's Speedo. Going back to our discussion of swimsuit season rapidly approaching. Sorry, Evan, couldn't resist.
I did swim in college, so there was a time when that may not have been quite as.
There we go.
Daunting.
And just to compensate for Evan's Speedo, I'm going to let you come up with the next MCLE passphrase, and later on in the show, you can drop in whatever you'd like. How about that?
Okay.
All right. Having done that, and if you need more information about getting MCLE or other professional education credit for listening to the show, head on over to the Twit Wiki at wiki.twit.tv. Go to the This Week in Law page, and we've got tons of information there for you. All right, moving on. Drew, as we've been discussing, runs this very social website and has had a patent case come up that we've been discussing. But there are all kinds of legal issues that impact FARC and the way that it operates. So we wanted to go into some of those, and most of them deal with the law of the social web. Love the sound effects, Sally. All right. So over on the Wikipedia page for Drew, it points out that you take a $6 a year salary from FARC, Drew. I'm curious, why 6?
It's 60,000. It's not 6. And it's because I live in Kentucky and money goes a long way here. Let me tell you.
So it's whiskey.
Just
I live like a king. I tell you what, it's great.
Yeah. Is it another planet that they made? Like Google made it?
Just about.
$6.
Seems like it sometimes. Yeah. I know my Wikipedia page has got a lot of errors on it. One of them is it says that I tried to copyright NSFW. Now, that's actually true, but I did it as a joke. But I think it still says, last time I checked, that it was turned down, the application, because I accidentally submitted nude photos of myself. And that's not true, but had I thought of it, I would have done it.
Awesome. Or maybe at least Speedo-clad photos of yourself. So the balance, though, is this part accurate? The balance of what you don't take out goes into FARC's legal war chest.
That is correct. And mostly because I learned that on my first company, which wasn't driven out by legal activity, but you always need some kind of a war chest. And having done this for 15 years now, the only things that have been existential threats have been legally based. So it's one of those deals where if you don't have, the war chest to fight this stuff, you're kind of hosed.
Okay, let's start. FARC, for people who haven't seen it or used it, is a site where community members can submit links, and based on their popularity, Drew, correct me if I'm wrong, they can get voted up or down. You guys exercise editorial control as well as to what's highlighted and what's not. But it's a link site. You're not hosting any original content there on the site. Is that right?
That's right. The shortest version I've ever been able to use to explain to anybody what we do is it's what if The Daily Show ran the Drudge Report.
That is awesome. So one of the things that you mentioned that you deal with frequently are DMCA takedown notices. How does that come about?
Yeah, so there's a couple of different ways. The first one is we have Photoshop contests where, everybody knows what a Photoshop contest is at this point, where people who, the original art, the photo or whatever, somebody who, owns that will come to us and say, you guys are in violation. You hosted our copyrighted file, which we don't. We just link to it. And then that all of the subsequent images that are in the contest are illegal, which is not true because it's parody. And then they asked to take those down. And I've developed a strategy of only responding when I get 3 complaints from the same person, which rarely happens. It cuts down my workload dramatically.
that there's some synergy with the fact that you're using a rule of 3 for your photography contests. That's
well, actually, for all
thing.
of them, I mean, any legal
Yes.
complaint, for the most part, like anybody will file off any BS complaint for any reason. And if they do it twice, they might still be mad. But if they're doing it 3 times, they probably are interested in sticking around. So that's usually the measurement I use to decide to react. Speaking of DMCA complaints, though, one of the other bizarre versions we've gotten, and hasn't happened too often, was, so we have little link images of the news sites that we're linking to. Well, in 1999, I didn't know anything about intellectual property law at all, and you'll notice that those are the logos of the companies we're linking to. Now, technically, we can't do that. Turns out nobody wants us to not use them because of the traffic they get. I mean, they actually send them to us, so it kind of works out. But one time, a few years ago, one of the large media sites we linked to contacted me and said, hey, you're using our client's logo. We didn't give you permission. You need to take it down. Now, I've since learned what this probably is. In the motion picture industry in particular, and I think my friend Will Wheaton was explaining to me, there was the early 90s, I think, there was a spate of lawsuits from attorneys claiming to represent companies' intellectual property from a copyright basis, filing lawsuits against movies and getting settlements for showing logos in movies. And that's why everything's got tape on it now, and everything's blurred out. And I have a feeling the people that contacted me were these guys. And I mean, or they could have represented the company. I don't know, but they said, please take it down. And I was like, well, go ask them, because I know you didn't talk to them first. Go ask them if they want me to take that down. And they said, well, why wouldn't they? And I'm like, trust me, dude, if you don't go ask them and I do this, you're getting fired. And they go, okay, we'll go ask them, but they're not going to say yes. And I never heard from them again.
Wow. So you get a bunch of bogus DMCA takedown requests. Do you ever get legitimate ones where you actually pull something off the site?
I don't ever get legitimate DMCA takedowns because we're pretty much protected. But interestingly, if people will just ask nicely, I'll probably take it down. I mean, a lot of the requests come in from 3 or 4 year old, pieces. Or, I mean, sort of an interesting segue is one of the other requests I get is from these reputation defender people, where we'll link to an article, like there was one about a judge who got caught multiple times using a penis pump during court. And I got an email from the guy asking me to remove the link because he's trying to clean his reputation up. I'm like, no, you're a complete idiot. What are you talking about? But other times it'll be stuff, where if people just go, hey, look, I was dumb, I was in college, and it was something, mostly harmless. And if they're nice, I'll take it down. But what I won't react to is people who go, something legitimate, like, I don't mind taking stuff down, especially if it's 10 years old. But I do mind if they go, or we'll sue you and we're going to take your business and your kids. And I'm like, you know what? That's like getting into an argument in a bar over politics with somebody and their first response is to pull a gun on you. I don't really react well to that.
Yep. Excellent point. Evan, I never thought that we'd have someone on the show. Years and years ago, we discussed said judge when those events happened. I never thought we'd have someone who had actually interacted with the judge in the way that Drew has.
I pretty much live on the internet. Unfortunately, it's a rough job.
I had totally forgotten about that, but that was a big deal,
I thought
And
that was
a big deal.
like what most judges do. Isn't that what most judges do? I thought that's why there aren't enough women judges, because they can't do that.
I don't know. Most judges that I've encountered in court are not smiling, so I have to think that that's not going on that much.
Well, is it supposed to make you smile? I just don't know. I'm not going to bring nothing. I'm going to say Speedo.
There's going to be more Speedo talk. You should stop now.
I am not.
It's going to be bad.
I'm not going to say that. Just going to leave it at that.
Leave it at that. One of the other things that you've had to deal with that are fascinating and that many companies confront, but we don't get to hear about it much because, at least in the case of these national security letters, you're not able to talk about it. But what sort of government requests for information do you receive, Drew?
Yeah, so I don't know if people have gotten smarter online over the years. I mean, just casually looking at YouTube would give you the indication that people have not gotten smarter over the years. But it turns out that the Secret Service is really, really good at combing the internet for threats against the president. Guess how I found out about that? And what was funny was that the first time this happened, it was very unfortunate timing. It happened on, let me do the math, September 7th of 2001, which was a Friday, and somebody threatened the president in a joke. And it was fairly clearly a joke, but because of what the Secret Service does, they have to respond to everything. And so this is the first time they called me, and they're like, hey, Lexington, Kentucky branch hit me up, and they're like, yeah, so we got, we see there's somebody on there. Can you give us the IP information? And I'm like, well, can you give me a subpoena? And sure. And they had one 10 minutes later. I'm like, well, there you go. I mean, what am I going to do? Get into a legal fight with the Secret Service? But what was reassuring about it is that they were very polite, and they were like, this is probably nothing. We check out thousands of these every week, and we know it's probably just some idiot, making a joke. But we have to check into all of this, and, if you could just help us out, we don't mind. And I'm like, yeah, sure. So that's about the only time that's happened. I think occasionally we've had FBI requests, but again, it's like, for lawsuits we're not involved in a couple of divorces, I think. But essentially, I'm unwilling to do anything unless they can provide a subpoena. And then if it costs money, they have to pay for it. And actually, when that's happened, I've never had any takers.
Have you ever had an instance where somebody tried to come after you as the result of comments or threats or any kind of harassing conduct that one of your users was engaged in against another user?
Yeah, there was only, you'd think it would happen more often, but surprisingly, there was only one time, and it turned out it was unfounded. And they didn't file a lawsuit. They were threatening, because that's what these people do. They're more like, they're patent trolls without patents, basically. They're hoping to bully you into, rolling over and just doing what they want. But it was, I got an email from a guy who actually had his signature. It was like Officer something or other, and it was a Connecticut Police Department. He's like, just wondering if you'd responded to so-and-so's email. And I hadn't, because he hadn't written me 3 times. I only had 2 letters. So I looked it up, and he was basically saying that we were in violation of a bunch of stuff, that people were making derogatory comments towards him that were slanderous, that they were making violent comments towards his family, and a bunch of other stuff. And so I was like, well, I guess I'll check into this, since there's a police officer emailing me. But I wrote the police officer back, and I was like, I don't know, was any of it illegal? Did he talk to you? And he's like, yeah, I've talked to him. I'm like, was any illegal? And he goes, well, it's not my position to decide. And I'm like, okay, something's going on here, because that doesn't make any sense. This is one of those, be a sorry thing if something happens to your website. So I looked into it, and it turns out we were linking to an article which had already been taken down. And the article was about a guy whose son played on a high school basketball team and was not getting enough playing time. So in response to this, he hired a private investigator to follow this guy around and dig up dirt on the coach. And the only thing he found was a 2002 YouTube video of this guy. And it was like, I don't know, raunchy, I guess. I mean, but apparently with a couple of bleeps, it could have been on network TV. And submitted this anonymously to the local high school board. And the guy got put on leave without pay, which was obnoxious. And so the comments that were slanderous on my website were, this guy is a douchebag. And so I wrote back, and I was like, you know what? It's not slander if it's true. And you kind of do look like a douchebag. And if you would like to sue me over this and have a court rule that, yes, illegally you are a douchebag, bring it on. You're going to have a bad result. And they went around a little bit like that. And finally, I just had my attorneys call and say, so why is this a police matter? And that's when the backpedaling started. So I would have probably gone full bore public relations on this guy, except I looked the officer up, and he actually seemed like a pretty decent guy other than this. And I was like, all right, forget it. I'll just let it drop. But yeah. Oh, and the violent stuff is that they said that this guy's kids are probably going to get beat up every day in high school as a result of what this guy does. I'm like, well, it's not threatening violence. That's what is that? Speculating that violence might happen, but not by the people making the speculation. So whatever. I was clear.
Yeah, that's a fascinating story. Do you do anything? What do you do to maintain civility on the site, if anything?
Yeah, so interestingly, I have a whole separate set of discussions I can have on maintaining online communities, because it turns out that online communities are like 5-year-olds. You can't just let them decide to do what they want to do, because then they're going to eat chocolate cake for every meal and tear up the house. So it turns out if you do just a little bit of discipline in the early days when you start the site, it gets baked into the DNA. And one major thing, and this strangely solves 90% of the problems, is you're allowed to say something isn't cool and you don't like it, but you have to say why. So if you say, oh, this article sucks, well, we'll delete that. If you say this article sucks because of blah, 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 we'll leave it up. And oddly, that circumvents most of the problems that you will ever have on the site. And the other 10% was something only recently. We have a much stronger anti-misogyny moderation rule. And interestingly, once we put that into play, it got rid of a bunch of people who had been causing problems for years, like by accident, and had no idea that was going to happen. So you do those two things, you're pretty much good to go.
And do you get blowback on any of those policies or stances that you're abridging people's rights of expression in any way, or do you care?
Oh, all the time. But no, I don't care. They can go somewhere else and do it. I really don't care. Or like Colin Cowherd says on ESPN Radio, you have a right to free speech, but not without repercussion.
Right. Well, good for you. At least I think our chat room is applauding everything you say here. And at least one person, P. Kelps, in there wants you to run for president in 2016. So bear that in mind.
Running for governor of Kentucky in 2015. So keep your eyes open for that one.
There we go.
Because why not?
Evan, anything you want to fire at Drew about his legal war chest and what it's used for?
No, I just really enjoyed hearing the stories about, that dispute you got, or, well, the people who were in a dispute using your site and how they tried to involve you with that. You would think that would happen a lot more, especially with the sort of stuff that FARC brings to the world. And, and that's a good thing, obviously. And just to make the observation that it's really interesting how local politics and local issues really get people stirred up into this frenzy that you don't necessarily see when they're talking about larger big issues. So who's the governor of Kentucky now?
Steve Beshear, but he's not running next time around. It's a bunch of just random guys, and I figure I could at the very least be less incompetent than them.
Yeah. I mean, you should at least be a Kentucky colonel if you're not already.
I am. As it turns out,
there you go.
I am.
Yeah, right on. Well, good luck.
To really build your base, you're going to have to work on your accent.
Yeah, well, I was born and raised here. So my parents are from Maine, and they burned it out of me.
Yeah.
Yeah. My kids have accents, though, so I'm set.
Hallie, we haven't heard from you in a while. Any comments or thoughts on the hazards and legal ups and downs of running a site like FARC?
I'm just enjoying it. I hadn't read it a lot, so it's really fun to read about a guy stealing a $4,000 electric bicycle. It runs out of power. He calls the guy who he stole it from for information on how to recharge it. Like excuse me?
Yeah.
It's good. It's better than fiction, and I write fiction. I like it.
Actually, we couldn't make this stuff up. I mean, that's not only a figure of speech, but I mean, it would just be unbelievable and sound stupid if it wasn't real. Yeah. Thank God for Florida. That's all I can say.
Yes, in so many ways. Evan, you want to drop that other MCLE passphrase into the show?
Baked into the DNA. That was something intriguing that Drew said. I thought that was interesting. So there were a couple of things I was going to try to embarrass you, but I'll just save that till later when you're not.
Oh, you're such a sweetie. All right.
I try.
Let's move on to picking our resident author's brain on copyright and fair use.
Thank goodness for Florida, says the guy from Kentucky.
I'm as surprised as you are, honestly.
Yeah.
So, Hallie, are you a member of the Authors Guild?
I am not. I am an e-publishing kind of freak and love all things self-publishing. And that's already stirred up the whole authors and publishing world enough. And the Authors Guild, they've been in this suit against Google since 2005. Don't they know what to do next? We just found out this morning that Google Plus is probably going to disappear. Like, really, Google has a whole lot of disappearing products, it seems. And that's been more interesting lately. So maybe Authors Guild can just wait till the so-called library project disappears. I'm being facetious, totally facetious. But
yes.
Do you want to explain a bit about where we started? You're the lawyer lady. Tell me where it started. And I know now they're trying to appeal.
Yes, this is something we've been watching for a very long time here at This Week in Law. The suit against Google and others by the Authors Guild and others. There's some complicated legal frameworks going on here. But for simplicity's sake, the Authors Guild against Google, the Authors Guild lost a big case against Google that it tried to pursue, lost at the trial level on fair use grounds. It said that the trial court found that the uses that Google is making of the books in its library project are fair use, that it's not destroying the market for those works, that use of the works are small enough that they fall within the fair use doctrine, and that Google can forge ahead with this. The Authors Guild is appealing this, and on appeal, we now know what the arguments will be. So that appeal is going forward. Personally, I don't have a whole lot of faith that the Authors Guild is going to get anywhere. I think that the trial court's decision was well-reasoned and well-written, and that the appellate court will wind up agreeing with the trial court, but you just never know. Things can go sideways or unexpected things can happen on appeal. So that's why we're watching the case, and the Authors Guild just filed its brief. Interesting that they made reference to Amazon's search inside the book function and tried to tee up the Google book search project as some sort of competitive response to that. I'd want to go back and check the dates, but it seems to me like search inside the book came along well after the Google book search project was underway. So, I don't know that they have their timeline exactly right here. So I wanted to just pick your brain about, what you think about books being scanned and whether this is harming authors. But before I let you answer that question, what do you mean Google Plus is going away? I know Vic Gundotra is leaving. Is that why you think the whole thing would go up in smoke?
They are. I'm reading articles this morning saying it may well be another. How many products have we used that are Google products that just, oops, we're not going to do that anymore? So apparently it may go away. I don't know. Do you use it a lot, Google Plus?
Yeah, I use it. I was hoping it would become my Facebook replacement when it came back, when it, was initially launched and had its enormous growth. And I think it's very popular among people globally. That's sort of my anecdotal impression based on who interacts with me on Google Plus. But, all of my friends and family and stuff are still on Facebook. So it really hasn't got the mainstream traction here in the US that I had hoped that it would. So it hasn't been able to replace Facebook for me. I do think it's a great tool, and they did some really innovative things, and I'm sad Vic Gundotra is leaving. But are people speculating it would go away simply because he's departing, Hallie?
Maybe that's why. I'm not sure why they're saying it, but it doesn't have the uptake they thought it would. My experience with it goes two ways. I actually was very much involved in writing the book, What the Plus, Google Plus for the Rest of Us, with Guy Kawasaki, who was a big promoter of it. But my personal use is like yours. I find Facebook, when I go onto Facebook, I feel like I know where my home page is. I know, sort of like my living room I can welcome people into. My sense on Google Plus has always been it's a little homeless. I'm never sure even where my page is. I feel like the interface was designed for engineers by engineers, and it's not as friendly. I even hate to say it, but it almost seems a little very female Facebook happiness scenario versus very geeky. We can be alone here and talk alone, guy, male engineers happening at Google Plus. But anyway, we'll see what happens. I don't know, but there's a lot of talk. I think you guys know too how you thought you were using Google IM that turned into Google Hangouts. Things just keep turning around. From a branding point of view, I feel like Google is teaching us not to trust anything they do. and that any product you start to like, it's like somebody makes a new shampoo and then you go to buy it again, it's gone. It's off the shelf. So I can't even understand why they think that's a good idea. It must be something. I'm married to a programmer. Maybe there's something heroic about throwing out what you did and starting again. But as from a consumer point of view, it's a nightmare, I think. So let me say quickly about the whole, you must have had 50 shows about defining fair use, but get ready for 550 more, because I think what's happening with ebooks and authors joining the ranks, in many ways, the Authors Guild is the very well-known authors who work with the traditional publishers. Then there's a million of the rest of us ebook people who are coming in, publishing really quickly, doing lots of interesting things, and are mashing up a lot of text and have a feeling like independent music people about using text any old way we want to, and quoting lyrics, which is a traditional copyright issue with most novels and writing, and quoting other pieces of books, and then fan fiction and everything going on. So I feel Authors Guild, they have their little teacup, and they're like, it has a feeling for me of being like 1,000 years old, Bartleby, I prefer not. I mean, it feels, I don't know, just not like what is actually happening, which is an amazing storm, very turbulent, in ebooks right now. They're changing. And I also got to work with Guy Kawasaki on his book, Author, Publisher, Entrepreneur, APE, which is a great book if you're interested in self-publishing, where, I mean, he and I sat down to dinner, and he's like, I'm going crazy with my publisher. I need to do something else. This was 2 years ago. And I'm like, dump them and start publishing on your own. So there's just so much more going on. And I don't know, I doubt, with all the trouble Google's gone to create this library project, and whether it's copyright infringement on a massive scale, as the Authors Guild says, or whether, as Judge Denny Chin says, it is basically a good thing. It's a sharing of good information, provides significant public benefits. We'll see. But I think it's like a war, a small war in a place where there's a gigantic battles all right. There's a small battle, big war going on all around them about how people will publish, how we will share our ideas, and fair use seems something that people now in e-publishing are pretty casual about. When you are writing fan fiction, taking somebody's characters, changing or using the plot of another book, that's a pretty interesting way to think about copyrighted material.
Yeah, it sure is. And I think you're raising some great points, Hallie, that we are going to see some wild west kind of developments in that area going forward as more people like you use e-publishing platforms. I know that Amazon has its own what's it called, Create Space, which allows people to self-publish there. My dad just went through that process, and the authors have to make all kinds of representations about the originality of their work, but I don't think they're really probably reading those representations very closely. So although Amazon's trying to cover its own hiney, I think the authors might find themselves on the wrong end of lawsuits if they're not careful about, those traditional rights clearance kinds of things. Evan, do you think this is going to be a big deal?
Which part is going to be a big deal?
The fact that authors like Hallie may have sort of a laissez-faire, kind of like indie musicians doing mashups and pulling things in and not having the resources or even really the knowledge to know that, hey, we should check with a lawyer before we go ahead and release this into the public. And so there's going to be a lot of potential copyright infringement going on that someone is going to want to sue over.
Right. Yeah. Well, I mean, it's going to depend on the sensibilities of the plaintiffs, obviously. If there's a lot of this stuff going on, there's going to be different ways of approaching it and different attitudes, different points beyond which conduct is not tolerable. I mean, it's a great thing about copyright to give the incentive to create, but that really can be, that somehow works in ways that you don't always expect, or not in ways that are intended. As far as it relates, if we kind of try to tie this back to the Google book search, the whole posturing of that, clearly there are new things happening with fair use that have happened over the last decade, I guess we might as well say, since the Google Print project started, became Google Book Search, and then we had this protracted litigation over that. I mean, I see those both as sort of separate issues, because with the Google Book Search situation, what's really the hallmark of that is the transformative use, in as much as it's making the content available for easier electronic access, electronic searching, what have you. And then with what sounded like what you're talking about, Holly, there's this greater ability to create, and those sort of seem like separate things, but the fair use analysis are going to be different. The Authors Guild is trying to drive home the point of commerciality as to why the Google Book Search decision is not correct. Whereas the transformative use of what's going on in the searches there seems to be something that, maybe this is just my own sentiment about this, but I get the sense that that's really the tide has turned, and that's well-established copyright law, that what Google has done is acceptable. Just like we don't really dispute anymore. Going back earlier this episode, we were talking about the Sony case, weren't we, in 1984? We don't dispute anymore that time shifting is a valid fair use. That's just, we don't debate that anymore. It's been the law for 30 years. I think we're going to see that aspect of the digitizing and making searchable of books to be something that just will not really debate much anymore. But then that is what gives the premise for all of these other innovative, crazy things that will spur the new kinds of disputes, because e-publishing will become so much more robust in that environment.
Yeah, that reminds me, Evan, that in the UK, this is a story we had in last week's rundown that we never got around to. They just now got around to, and the US has not ever gotten around to, specifying in the law that it's legal to rip a CD. So that's now made express under UK copyright law, has never been made express here. And, you used to get people arguing that point in court. I think it came up in the Napster case that there was some big admission by one of the lawyers that it might be fair use to rip a CD. And that was never a concession that had been made before. So yeah, these things that we take for granted might eventually become actual concrete specified law like this one did in the UK.
Yeah.
Let's move on to our resource and tip of the week, and then get on out of here and let you guys enjoy your weekends. Our resource of the week is for those who might be thinking about going to law school, or interested in the state of law school. Oops, I'm on the wrong page. Hold on. I jumped over to last week's show so I could refer to the UK. This is from noodle.org. It's an infographic on the current state of law school, and gives you all kinds of information on the job market for new law school graduates. So if that's something that is intriguing to you, you should check this out. It tells you about law school sizes and how they've been cut, what sort of tuition you have to pay and debt that you might go into, and then what sort of job you have to look forward to after the fact. It's all kind of dismal and bleak. So it's something good to check out and understand the information there if you're thinking about embarking on a legal career. And then our tip of the week comes from Drew, from his battle with the patent troll that we discussed earlier in the show. He's come up with a lot of good and perhaps counterintuitive ways that you should approach a patent troll strategically. So, Drew, what was the most important point that you took out of the experience?
Yeah, when people try to fight patent trolls, they usually try to go after the patents because they're usually really badly worded and vague. Well, it turns out there's also something else you can do, which is what I did, which was, instead of attack the patent directly, you can deny that you infringe it. And the reason why this matters is because we're talking about a fairly vaguely worded patent here, and the judge is much more likely to agree with that than they are to overturn the patent. And it's a fairly easy thing to do. In my case, it was, show me screenshots of where we actually infringed. But it's even more interesting because I was working with the podcast troll, as I alluded to earlier. And it turns out that what the patent clerk thought was novel about that patent was that there was a list that was downloaded into a device. And it turns out that the Corolla show doesn't even indirectly infringe on that because there is no list that gets downloaded into any device. And so I recommended that they go ahead and claim they don't infringe based on that. They may not have to because the EFF filed a re-exam and it was granted today or yesterday, I think. And at any rate, so they may be out of the woods, but step 2 is going to be deny infringement and make them prove it.
Yep, that's a really good tip. I hope folks will bear that in mind. And we hope that you will bear in mind that we record this show each and every Friday live at 11 o'clock Pacific time, 1800 UTC. That's when you can jump in and have fun with us as we record the show live. You can go into our IRC and chat with us there. If you can't do any of that, don't worry, though, because the show is going to show up for you on demand in many different ways, hopefully via a very reliable and non-priced out internet connection. And you can find it at twit.tv/twill. You can also find it at youtube.com/thisweekinlaw. So see if YouTube pays for the net neutrality fast lane. At least you'll be able to get the show fast there. Of course, those sorts of costs will get passed along to the YouTube users. So we have to bear that in mind when we're thinking about all the net neutrality policy considerations. Where else can you find the show? You can find it on iTunes. You can find it on Roku. You can find it all kinds of different places where podcast content shows up. So you can also subscribe in any kind of podcatcher that you like. More information on that over at twit.tv/twill. We love to hear from you between the shows. You can email either me, I'm Denise at twit.tv, or Evan, he's Evan at twit.tv, or hit us up on Google+, where we continue to have a page and where we get a lot of interaction in our community over there. If you, like my friends and family, are over on Facebook, then head on over there too. We've got facebook.com/thisweekinlaw, where we love to hear from you about what's on your mind as we prepare for the shows and feedback about the shows we've already done. Evan, anything else?
No, that wraps it up. That's really good. We're out there. Lots of places.
So, Hallie, it's been great having you back on the show. Thank you so much for joining us.
Thank you for the invitation. And I'll have to go get those snacks. They sound great.
Yes, they do. And they would go very well as someone was reading your book, Founders Less Than 3, or Does This Startup Make Me Look Fat, your other Kindle book. So do you have any new books in progress we should be looking forward to?
I am going to write a follow-up. It's funny, the book that I wrote, Founders, is about the Techstars experience in the accelerator program here in Boston. And there's one team I talk about. It's fictional. It's not quite real, but it's based on a team that we just found out yesterday. They sold their company after 2 years for, just compared to California, a small $10 million. But you can read all about the experience that what it was like for them to start their company here in Boston. And it's got a real life happy ending. So I am writing a second book about not that, but the woman entrepreneur and her next adventure. So
that's awesome. I'm really looking forward to that. Your books are always funny and entertaining and educational. So I'm glad you're still at it. Hey, Drew, it's been so fun chatting with you today. You are such an interesting fellow and have had great experiences and tangles on the legal side that I think have been really illuminating for everyone joining us today.
Yeah, thanks a lot. By the way, speaking of healthy stuff, this is what I'm feeding my kids for dinner. It's a peep cake.
That is awesome.
It's not very healthy. I don't think it's not corn syrup free in the slightest.
No, not at all in the slightest, but they are Peeps. And what could be better than that? I think Newt likes Peeps, right, Hallie?
Oh, he can't get enough, but there are never enough green ones. They're all pink and blue,
All right.
So
just
what are you going to do? Here.
Have him keep the crumbs off your keyboard.
There. Yes.
There you
He
go.
likes the
Bye,
green
Newt.
ones. He's got green sugar on him.
It's been great chatting with you and Newt. And Evan, it's been great as usual getting together with you at the end of the week. I feel like I've gotten Aereo and net neutrality and all our other topics out of my system now and can move on to other things.
Yes, I'm sure there'll be something great to talk about next week, and I'll look forward to it. So, Drew, awesome talking to you. I grew up in Indiana, so we told jokes about people from Kentucky, but so today all stereotypes have been completely done away with.
No, they're still true. Don't worry about that. It's true.
Good. Hallie, great talking with you again. Really,
Always
really enjoyed
good. Always good.
Yes, good time.
Have a good
thanks
weekend. It's really the weekend finally. So
for sure. Right on. Well, thank you. Talk to you all later.
We're coming up on summer. And while we do have an intern, Sando, who is continuing to work with us, he will eventually someday move on and consult that state of the law school chart and find himself something that needs to occupy him, hopefully not into the wee hours of the night too often. But we never would have even thought of having someone assist with the show. And then Franklin Graves got in touch with us a few summers back and was our very first in a long line of illustrious interns. So if this is something that you think you might want to help out with, we'd love to hear from you. San has been helping us primarily with bookings. Franklin did the great bumpers that we have in the show to distinguish the different topics from one another. There are all kinds of ways that you could help with the show. So if you have ideas on how that might come about, get in touch. We'd love to hear from you. And with that, we will see you next week on This Week in Law. Take care.